Welcome to your second last domain, which is legal regulations, investigation, and compliance. Starting here, we need to actually look at what IC squared from the Candidate Information Bulletin tells us. It tells us that the legal, regulations, investigation, and compliance domain addresses ethical behavior and compliance with regulatory frameworks. It includes the investigative measures and techniques that can be used to determine if a crime has been committed and methods used to gather evidence, that is forensics. A computer crime is any illegal action where the data on a computer is accessed without permission. This includes unauthorized access or alteration of data, or unlawful use of computers and services. This domain also includes the understanding that the computer incident forensic response capability to identify the advanced persistent threat, or the APT, that many organizations face today. Now, the objectives, what we'll do here is look at a couple of major legal systems: global, common law, civil law, similarities and some differences, IT-related laws, computer security-related crimes, the examples, and then policy standards, procedures, and guidelines, which is quite a nice topic as well, because we require that within organizations to make sure that we can take action. Now, also, incident management is really important. Do you have a computer emergency response team? What they do? Computer forensics, discovery of the evidence, collecting of the evidence, when, how to do it, digital evidence and the collection processes, a first responder, and forensic investigations. Now, also, legal systems in a worldwide fashion says civil law, also known as continental European law, which is the most widespread legal system in the world. There's common law, customary law, religious law, mixed law, and some countries you'll see do that. There's administrative law, and we'll see some examples. International law, maritime law, also known as admiralty law. And then final martial law, which is not a topic we'll cover at all. However, it's important to understand martial law is that the army takes charge, and things do change a bit as well, but it's outside the scope of this lecture. A good example here, always in flux and things change here and there depending on the country and who's in charge of it and so on. And as you can see there, the blue, civil law, common law, mixed law, customary law, and then also depending on some religious issues as well. Now, when we look at civil law, it traces its roots back to two beginnings. Intellectualized within a framework of late Roman law, where the core principles are codified into a referable system which serves as the primary source of law. You have the Napoleonic Code, 1804, after Napoleon Bonaparte, and then also the subgroups from the civil law. We have Napoleonic, Germanic, Scandinavian, and Chinese, where that falls in China except Hong Kong and Macau. Now, common law is also called case law, English in origin, and attempts to right the wrong, fulfill obligations set in place by an agreement like a contract, or settle a dispute. It is based on legal precedents, past decisions, and also societal traditions. It is based on the principle that it is unfair to treat similar facts differently on different occasions, which is equality. Now, when we look at common law of criminal law, also known as penal law, it is based on common law, statutory law, or a combination of both. It deals with behavioral conduct, and there's objective of punishment, which is retribution, to fix it, to get it back to the original state, deterrence, to make sure that doesn't happen again, incapacitation, which means that the person is no longer able to actually do something like that, and it may be, for example, be a jail term, rehabilitation, and also restoration. Now, when we look at this, some similarities and differences of common law versus civil law. So if we look at both there, the source of the law, where it comes from, we've got source of law, case law, statutes and legislation from a common law point of view. Civil law is statutes and legislation. Then also within common law versus civil law, the lawyer's function in a common law controls the courtroom. And also in civil law, judges on the other side dominate trials. And that's where you can see from the judge's qualification, where the lawyers control the courtroom, judge's qualification is experienced lawyers appointed or elected. And in civil law, you can see judges dominate the trials, which is career judges as well. Then degree of judicial independence, high in common law, and also civil law, also very high, but separate from the executive and legislative branches of the government as well. Juries, in common law, provided at a trial level, at a civil law, may adjudicate in conjunction with judges in serious criminal matters. And then policy-making law, at a common law, we have courts share balancing power. And then in civil law, we've got courts have equal but separate powers as well. So just go through this table and make sure you understand it. And that's the most common differences of the two different laws there. Now, also interesting fact, when we look at this, criminal law is enforced by the government. Civil law may be enforced by private parties. So if we look at a very interesting case a few years ago, O.J. Simpson was charged criminally by the government and found innocent. However, after he was found innocent, the O.J. Simpson was charged in a civil matter by the deceased family and found guilty. And then later as well, and there is not, when you found guilty in a civil matter, it is monetary damages as well. Well, now O.J. Simpson is serving a jail sentence for aggravated assaults with a deadly weapon, trying to liberate some of his mementos. Now, when we look at common law, tort law is a body of law that addresses and provides remedies for civil wrongs, not arising out of contractual obligations by the tortfeasor. That's the person committing the tort. Punishment normally takes in the form of monetary damages. We have categories. We have proximate cause, negligence, intentional torts, statutory torts. And you've seen it as well. There can be Product Liability Directive, Consumer Protection Act, business torts, which is quasi-torts as well, workers' compensations, nuisance, and defamation. Now, tort law examples can be anything from dignitary wrongs, invasion of privacy, civil rights violation, economic wrongs, patent infringement, copyright, trademark, unfair competition, and then liability. Vicarious liability, for example, a person fell on the floor in a shop because somebody spilled some oil in one of the aisles. Consent and warnings. There might be a warning sign out there, and it actually reduces your liability from a tort. Comparative or contributory negligence, which means that a person did something on his own behalf and actually created the problem as well. So that might actually lower your liability as well. And then finally, illegality, which means if a person committed the tort, however he or she was actually committing an offense at the same time, something illegal, your liability may be lessened as well. Now, also, a couple of other samples, we can look at intentional torts. Those are assault, battery, false imprisonment, intentional infliction of emotional distress, IED, happens often, copyright infringement. Then also property torts, trespass from land, your land that you have, somebody trespasses in that, that's an example. Also chattels, which is personal property. And then conversion. A defendant must have intended to exercise control over the property in a manner inconsistent with the owner's rights. And you can see that where somebody either converts a company and somebody becomes another director. We've seen this quite often locally in South Africa, where companies suddenly have new directors. So they interfere with the ownership and intended to change that. So that is wrong as well. Then also from a common law point of view, administrative law. It's also known as a regulatory law and considered a branch of public law. It's created by administrative agency by way of rules, regulations, orders, and decisions. Areas covered by administrative law include items like the police, international trade, so you have to pay forex and custom duty and excise, immigration, transport, manufacturing, broadcasting, taxation, and also the environment. We've seen that green taxes coming up as well. Customary law, which is really interesting because regionalized systems, it means that the modern codification of civil law developed out of the customs of the Middle Ages, expressions of law that developed in particular communities and slowly collected and later written down by local jurists. Now, You've seen it in South Africa, you've seen it as well. We've got tribal law, part of the customary law as well. It reflects society's norms and values. Custom in law is the established pattern of behavior that can be objectively verified within a particular social setting. Most countries combine customary law with another legal system as well. Religious law as well refers to ethical and moral codes taught by religious traditions. We have canon law, which is Christian law, halakha, which is Jewish law, which means walking, Hindu law, we've got traditional Islamic law or Sharia, guided by the Quran or the Sunnah, means trodden path. It covers all aspects of a person's life. Mixed law, convergence of two or more legal systems as well. We've seen a couple examples of mixed law. We've got Holland, we've got Canada, which is Quebec only, USA, Louisiana, another state, Roman Dutch law, South Africa, Zambia, Zimbabwe, Sri Lanka, and Guinea all have mixed law as well, based on Roman Dutch law, and also Scotland is another example. Now, problems when reporting crime is usually because there's lack of international cooperation. If you actually determine a crime and somebody's hacked into your system, you have to either contact your ISP, there's a problem, and you realize the guy jumped from, say, China, for example, and then you have to contact them. And so cross-border issues is huge. Now, there is a Council of Europe COE Cybercrime Convention, which has defined a couple of international cooperation. Also, the problem is companies do not want to report crime. It's more of an embarrassment factor. However, international law moves towards disclosure. We've seen that as well, whereby Visa and MasterCard had to disclose that they have been compromised, or some of the cards have been compromised. And a very good example in the UK, there was a building society who actually one of the laptops went missing. And that's a crime that have to be reported as well. And however, due to the fact that they didn't report it immediately, and it took about a week for them to investigate, they were fined heavily. So the failure to disclose may lead to penalties. Now, when we look at information technology law and regulations, there's intellectual property we can actually look at. There's things like a patent, a trademark, copyright, and those differ from country to country as well. Trade secrets. Now, what's important when you look at these items, you need to consider how long are they applicable for as well. Licensing issues on your software, design rights, and then also there are issues around privacy, customer data, liability, computer crime, international cooperation or the lack thereof as well. Now, intellectual property rights, the purpose is to protect tangible, intangible items and property from those wishing to copy it or use it without due compensation to the inventor or the creator. For example, a patent is an idea. Copyright is the expression of an idea. And then trademark, a symbol representing an idea. Now, the advantage, if you look at a patent, the advantages of a patent is that it is the strongest form of IP protection. It excludes others from using your invention, although if they want to use it, you need to actually have compensation, but it's usually about 20 years. Once granted, it is published in the public domain. There is a World Intellectual Property Office, which have some rules and so on. However, we've seen from international, there's not real cooperation and does not override any patents. The disadvantages of patents includes patent trolls. You actually have companies being bought up to just get the patents so that they can actually sue other companies because they are using their patents as well. So there's legal loopholes and also third-party abuse as well. That, once again, is whereby a third party might register a couple of things, seeing that it's being developed and so on, and then claim the actual patent on the product that he or she has not developed. Trademark, from an intellectual property point of view as well. It can be anything from a word. As you can see there, Starbucks, very good example. Yeah, color, green, name, the whole Starbucks coffee. Sound or symbol. If you've ever seen that Intel Inside advert, it actually has a symbol coming up and then there's sound playing, and then also the product shape as well, the Coca-Cola bottle, for example. Also, when you look at trademarks, it includes goodwill, meaning that is adds some value to the sale. Although it's not tangible, it actually means that it gives that value. People want to buy the product. This is also critical when you look at mergers and acquisition negotiations as well. Copyright, it covers the expression of an idea, its writings, recordings, software programs. We can then patent protection. It is different from country to country. Some countries you require a product to be registered as a copyright product. You need to register that copyright. In South Africa, we don't require that. It just means that the author becomes the owner of the copyright as well, unless it is commissioned work as well. So, and it changes over time as well. It has a limitation on a lifespan. For example, it says the copyright may exist for 50 years, but when? Since it was published, since the author has passed away, and there's many dependencies on local legislation. We have trade secrets, one of our strongest and usually a jewel in the crown of an organization. So it's either a formula, a practice process, design, instruments, pattern, or compilation of information. Now, I've got Coca-Cola as an example here because it should be confidential, the Coca-Cola recipe, as business has competitive advantages. So protection of that organization should take some reasonable step to protect its secrecy. As I said, crown jewels in organization as well. There is no expiration date for a trade secret. Software licensing issues around that are different categories. We've got freeware, shareware, commercial, open source. Academic and also cloud enabled. We see the Adobe Cloud software coming out now as well. Now, when we look at the main differences between public domain and freeware, the main difference between public domain and freeware is that freeware is still owned by the author. When it's put in the public domain, then you lose that right of that ownership because you gave it to the public. Then also, you have a master agreement and end user licensing agreement as well. That is when you actually use the software, you have to agree to that as well. Just from that point of view, the only item I can identify there, which you actually, it's different that you most probably don't know, the academic software licensing. It means if you're a student, you've seen it most probably in the Microsoft environment. You can actually get a Microsoft Office product at a highly reduced rate because you are a student, but you're required to prove the fact that you are a student with a student card or any other invoice or statement. Now, when we look at software protection as well, encryption, from a legal point of view, we've got import and export restrictions. There is a Wassenaar arrangement where we have 41 participating states. The ITAR restriction, which is the International Traffics and Arms Regulation, also restrict the export of cryptography, and those are to enemy states. France, we have a law of trust in the digital economy. It was totally outlawed. Encryption was totally outlawed in France, but in 2011 and also since basically 2004, if it is used for authentication and integrity, it can be used. Other uses, it has to be declared from the EU. If you actually export it to other countries, it requires explicit authorization. And also employee privacy as well, employee monitoring as well. There's an abuse versus fair use clause in most constitutions as well. So if a person uses email on a personal basis as well, and it's not trade secrets and it's not a high secure environment like Department of Defense or anything like this, it is normal use. That's fair use. However, if you start sending out anything against the acceptable use policy, like chain letters and things like that, that is abuse. Also, authorized usages for electronic communication, and this includes anything like internet, email, instant messengers and things like that, telephone, voice over IP, and waivers as well, different answers from different countries as well. So when you actually look at this, you need to understand the question. You need to understand what is applicable as well. For example, a waiver may be that you are allowed to use the system, but the company will monitor you from time to time. Now, if you agree or don't agree with that, you can take that up with HR, for example. But it is all different as long as you don't do anything illegal from a company point of view. For example, if you sniff a guy's personal email, you're invading his privacy, and certain laws may address that. Consider that there's a difference between email and snail mail is an audit log. What I mean by that is email, anything you do on a messenger, instant messenger, Skype or so on, there are audit logs, and that's why it's so important to understand that you as a user should not go outside the scope of the acceptable use policy, and also as a company you cannot invade the privacy of the end user as well. Now, when we look at liability, there's legal responsibilities from different parties as well. Penalties, the main difference between of certain penalties, for example, civil and criminal penalties. The one is a monetary penalty, the other one is actually loss of freedom. Negligence, which means acting without care, and also due care, we've seen it before as well. It means that the requirement that officers and other executives with fiduciary requirements meet the requirements to protect the company's assets, which is a moving target, of course. Business vehicles may protect partners or members. However, negligence will negate this protection. Due diligence is the degree of prudence that might be properly expected from a reasonable person. Now, a reasonable person is a very important point, because reasonable person or reasonable man is a legal term to say if we don't have a precedent set already and a person has committed something, would a reasonable man have done that? That's a question that's normally posed. A reasonable person, a man, is a legal term, as I said there. It's a continually moving benchmark, and it requires commitments onto an ongoing risk analysis and risk management process, which you've seen earlier as well. Computer crime. Computer can be used as a tool. It can be as a target of a crime. It can be a victim. Computer could be incidental to a crime, whereby we have go and look at additional evidence. For example, if a user has committed a crime on a workstation, however, a server has got logs, you can actually look at that as additional evidence. Now, also, there are reasons why we have criminal behavior. There's financial gain. These are greed usually. Revenge, because I don't like somebody. Temptation. And I always say to the guys, there are three types of persons that do exist in your environment. The first one is somebody who will look for crime to commit. He'll try to commit fraud. The second one, you won't look for it, but if it comes past his way and it looks easy, he might not get caught, he'll try it. And the third type is to make his family survive. So that's what I say, look at that. Also, egotistical behavior, because I can do that sort of like a narcissistic trait and, godlike complex as well. This often you see within investigations as well. Now, so samples of computer crimes include insider abuse, writing viruses, white collar or financial crime. These are your fraud in corporate espionage. It happens often. Hacking, child pornography. Now, when also from a child pornography point of view, if you stumble across that within an organization, what do? You have to stop everything, because this is a criminal offense and you have to report this as well. The interesting thing is as well, when you look from a legal term point of view as well, if you work for a company, and let's actually look at normal, not child pornography, but let's look at any other crime. You are allowed, because you are working for a company, you're doing an investigation, and you have a mandate to actually go look at evidence and document these things. However, if this crime is reported by you to the police, to any force, you are now an agent for the police, for example, and you cannot do anything without a warrant. So it's actually quite interesting to look at that. Electronic stalking. Organized crime, we see the 419 scams, syndication, see a lot of frauds happening within banks, terrorism, killing using a keyboard. This is cyber war. We see that quite often, people talking about that and coming down the line. Identity theft, and also social engineering as well. Now, social engineering, not a crime, but it's used to commit crime often. Now, incident response is an IT service management process. If we look at ITIL, the IT Information Library version 3, it means that it says that an incident is an unplanned interruption to an IT service or a reduction in the quality of an IT service. So when we have that, we need to look at our response capabilities, our policies and our guidelines. So what do we need to do? Our response. Now also, when there's an incident, we need to actually consider, are we going to have triage? Now, triage comes from a war term where you had medical tents. And if two wounded soldiers come in and you see that the one will not survive and the one has got a great chance, then you'll actually select, and this is called triage, that the one that is going to not survive is actually make sure his pain is taken care of and leave him and focus on that one that will survive. Now, from an incident response point of view, it means exactly that. So are we going to recover the system? Are we going to a new system? You have to make all these decisions as well. Also, when it happens, do we contain the actual incident? Investigate that, and then we have analysis of the treatment. This has to be linked to a service level agreement. And then also finally in the incident response, we'll have debriefing, which is metrics, measurement. How can we do it? What lessons have been learned? And also there's what a lot of guys refer to as well is a thing that a lot of staff don't like, because it's a root cause analysis, looking at the whole process, discussing and documenting that as well. And then finally, possibly public disclosure as well. So the objectives are incident detection and recording. We're going to classify and do initial support on that incident. We're going to investigate and diagnose to see what's wrong. We're going to try to resolve that and recover a system. We're going to close incident closure, and then finally, we're going to look at the ownership, monitoring, tracking, and communication, making sure that doesn't happen again. Establish an incident framework for management, and then finally, evaluation of incident framework for the management as well. So we need to look at all those items when you look at incident response. Then computer forensics, which is quite a big topic lately. The goal of computer forensics is to examine digital media in a forensically sound manner with the aim of identifying, preserving, recovering, analyzing, and presenting those facts and opinions about the information. Now, the word opinion there as well. Can an opinion be evidence? Yes, as long as it is presented by an expert on that evidence item. Now, when we look at computer forensics, we have to look at the crime scene. We have to secure the crime scene. We have to do the digital evidence. We need to make sure we collect that securely. We have to have our own guidelines. Now, also, when we look at the law from computer forensics, some countries have adequate laws and adequate processes to look at computer forensics. However, from an evidence point of view, if you don't have anything in a country, it falls down to the actual rules of evidence. If I actually obtain the evidence and I analyze it and I get to a result, and I can repeat that and get to the same result, and the plaintiff or the other defendant, the opposition, can analyze and get to the same evidence, it is admissible, as long as it's still subjected to the 5 laws, which we'll see later as well. So then also, chain of custody is really important. You can see there's a couple of questions we can pose to look at if the chain of custody has been broken or not. Best evidence, that is evidence that can stand by itself without any other evidence requiring to support it. Also admissibility requirements. And often I say to the guys, when you look at here, it can be true, sufficient, complete, relevant, and usable as well. It's also one of the admissibility requirements. And then also rules of evidence, which we'll see as well. The evidence, we actually have evidence and potential evidence. So we just make sure we recover all those things and make sure we actually securely collect it in a secure fashion. It falls under the Digital Forensic Science Research Workshop. It deals with evidence and legal systems, correctly identifying a crime scene, evidence, and potential containers of evidence. And then the process which we need to worry about is collecting and acquiring that evidence. So from a computer forensic point of view, we need to look at search and seizure, the process that we have to do that. We make sure that everything is correct and documented properly, because if you go to court and testify, it's very easy to, if one item is not trusted, it actually put a untrusted blanket all over your other evidence items. We need to secure a scene, make sure that nobody can tamper in that. You've seen this crime scene tape, but often we use it to make sure that nobody actually steps past boundaries, securing the actual evidence. So we go through the whole process of getting, then making forensic images with either duplication hardware or software. And then once we've done that, it is signed with a secure hash algorithm to make sure that nobody tampered with that. And then we have to secure original. Might lock it up and make sure that nobody can get to that. So if any point in time we can actually either destroy it or return it to the actual parties. Then we have to analyze the evidence using special software tools. And after we've analyzed that evidence, we have to generate a report and prepare to testify in court. Now, the 5 laws for digital evidence are, when we look at evidence, it has to be admissible in court. Now, what that means from an admissible point of view, it has to relate to the actual investigation, the actual crime that took place. Nothing that is outside the scope. Authentic, complete, accurate, and convincing. Now, consider in each instance the plaintiff and the defendant stance on that evidence as well. The evidence need to go through what they call an exploration phase as well. So if you do have evidence, you need to declare that to the opposition so that they also can review the evidence. Nothing is a surprise, and they have to do the same. Now, digital evidence is a thing like hearsay, so printed records and so on. Now, depending on a record printed and computer evidence and so on, you need to have an expert to testify how it was generated to make sure it's admissible as well. Secondhand evidence is also made by someone other than the witness, a statement, for example. It's normally not admissible. It's pending as well. So depending on the country and courts as well, there are exceptions of what can be admissible or not. Business record exemption, computer-generated information, that may be submitted as hearsay. It may require an expert to testify how the information was created, and reproducible requirements as well, as I said earlier as well, if you can reproduce and get to the same result. Now, also when we actually worry about, when we look at digital evidence, there's definitely a lifespan, and we have to, when we secure the evidence, we need to make sure that we actually go from volatile, fragile, up to non-volatile. There's definitely a window of opportunity to grab these things. Collect when you can, else the data may disappear. For example, if it's a log may be overwritten. So if you take a week to get the evidence, a very good example is one of the investigations that I had to do, and I had to obtain web logs. The whole formal process we went through to actually request it, and to request it from the service provider to extract the logs for us and give it to us. Now, the process and the red tape that went around that, it took a few days to get it, and we've lost basically the data purely because of that window of opportunity. Now, example is you can order volatility, for example. Let's actually look at first, grab those things, what in RAM. Now, a crime could have been committed right then. You want to know what programs are running, what is actually in the registers and so on. Then victimology, which is the relationship between the victim and the perpetrator. Hard disk drive printouts and then backups. So you can actually look at from a volatility point of view as well. Chain of custody, a couple of questions we can ask. What did I receive? Document those things. Who gave it to me? Was he a trusted party? Was it sealed? When was this given to me? You have to identify an exact timestamp. It has to be spoken for every point in time. A very good example is the O.J. Simpson case again. The blood ampule that actually could have proven his guilt was, nobody was looking after it, or no, it was outside the chain of custody for a few minutes. So it means it could have been tampered with. So that was thrown out of court. Where did this happen? So identify the location. How was it given to me? Tamper-proof, sealed, signed. If you can answer those questions correctly, document those. Your chain of custody is usually trustworthy. Do's and don'ts. Let's minimize handling from the data. Account for any changes. Document those things. Comply with the 5 rules of evidence. Do not exceed your knowledge. Biggie. Follow policy and obtain written permission. Accurate image creation. And then prepare to testify. Ensure that your actions are repeatable, and this is very important for evidence. Work fast within a time window. Proceed from volatile to persistent. Do not run any programs on the affected systems because you're going to change it. Act ethically and also in good faith. Attempt to do no harm. Again, do not exceed your knowledge, skills, and abilities. This will break a case. Know local laws and regulations. Have approved procedures for handling incidents. If you don't have in your organization, start documenting them. Look at them if you do have them. So you can actually look at, if anything happens, who do we contact? Do we contact internal audit or HR, for example? Who would you contact? Either internal audit or HR? Human resources, rather, because they know the policies and they know what to do. Ensure that all handling of sensitive information is compliant with regulation. Custom information, make sure they don't get out there. Follow best practices and document all steps of an investigation. Also, when you look at ethics from a legal point of view, go through the IC² Code of Ethics. Know them. You also have the Internet Activities Board. You have the RFC 1087, which is the ethics and the internet, and you also have RFC 2850, which is a charter of the IAB. You have the Computer Ethics Institute. You have generally accepted systems and security principles, and then also information ethical standards. Make sure you know the ethics. Go through RFC 1087.